I'm a Rucons. We back in the building, son. Yeah. Once again with another dope video, man, about these sovereign rights. Yeah, a lot of characters and naysayers. They say it was a CIA design um, where they they coined the phrase conspiracy theorist. You know what I'm saying? And they coined the phrase sovereign citizen, which is actually a oxymoron. An oxymoron to the simple fact that it's opposite because you can't be a sovereign and be a citizen. You get what I'm saying? So how can you be a sovereign citizen? Okay, yeah. But those are the misleading words that they throw out there to be like, the people just talking, make you blow people off and not take people serious when they make you think that they have some form of schizophrenia or paranoid about this or paranoid about that. Nope. We're going straight to the horse's mouth. We're coming straight out the book that they're guided by, and we're going to judge by their actions to see if they're in accordance with these particular writings ascribed to them, for them, that they have pledged allegiance to, that they have taken oath of office to uphold. And we're going to hold them to those oaths because what? We are the people. We the people. I'm a Rucons. We the people. Rights and sovereignty. Only people are sovereign and have rights. First sentence. First sentence. Only people, not persons. They didn't say persons. They said people. I'm the type of person. No, I'm not the type of person. I'm the people. You know what I'm saying? See, a person can be equated to a corporate entity with 3/5 of a human's rights, with only 3/5 of a human's rights to be exercised at any given time. But if you are the people, you are the human. You are the living, live, flesh and blood, sentient being capable of presenting themselves in the proper format and appropriate persona. And to identify as such, a sovereign as such, who has rights. Only people are sovereign and have rights. Bureaucrats in their capacity are not sovereign and they have no rights. So who's the boss? If you the sovereign, then you got rights. And the bureaucrats are not sovereign and have no rights. Who's the boss? Okay. Stop watching so much TV. I know. It's a hard pill to swallow. They have authority given by the people and are subject to the statuses. See, the state cannot diminish the rights of the people. See, that's Hurtado versus people of the state of California. 110 U.S. 516. Now, the assertion of the Federal Rights Bill of Rights, when plainly and reasonably made, is not to be defended under the name of local practice. Or should I say defeated? It says it is not to be defeated under the name of local practice. Excuse me, I read that wrong. I was reading a little bit too fast there. But that case law is in Davis versus Wilsler. 263 U.S. 22 and 24. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. And of course, that's Miranda versus Arizona. Now, we see Miranda versus Arizona and a couple more of these plenty more times, and they've been used frequently, man, to assert people's rights, their sovereign rights. You know what I'm saying? Their rights and their sovereignty. You know what I'm saying? So backwards and forward. We're the sovereign that gave them authority to have the choice whether or not to affirm and take oath to Constitution that was written by the people. The five civilized tribes who signed and gave consent and permission to the United States Governmental Services Corporation to give safe harbor to them as for traffic, trade, and commerce on the land, which is the longest running treaty on the planet. Have they no respect, honor, or integrity? As they quote the Bible in many of these inserts here. Whereas where rights secured by the Constitution are involved, there could be no rules making or legislation that would abrogate them. Miranda versus Arizona, as we see, there can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. And that's Shearer versus Cullen. 481 F 946. Now, sovereignty itself is, of course, not subject to the law, for it is the author and source of law, the L. And that's Yikwo versus Hopkins, 188 U.S. 356370. To deprive the people of their sovereignty, it is first necessary to get the people to agree and submit to the authority of the entity they have created. That is done by getting them to claim they are citizens of that entity. Now, see the Constitution for the U.S. 14th Amendment for the definition of a citizen of the United States, which is chattel property that has no rights. You know what I'm saying? When you look that up. And I think did I even pull up? I think I pulled out that. Let me see what we got here for you. Congressional record. And this is about the Pizza Treaty Friendship also. Now, where did I see that information? Now, this is a full congressional record. Ooh, they even got it in here about the kidney centers. Yeah, we like to stay savvy on all this. Now, since we're right here, let's go ahead and tap in on this right quick. And this is United States relations. This is in regards to treaty obligations too. United States relations with Morocco has strengthened in the decades and centuries following the historic treaty. For example, during World War I, Morocco was aligned with the Allied forces in 1917 and 1918. Moroccan soldiers fought valiantly alongside the United States Marine at Chateau Thierry, Montauban, and Sessions. During World War II, Moroccan National Defense Forces aided American and British forces in the region. Morocco hosted one of the most pivotal meetings of the Allied leaders in World War II in 19 in January 1943. United States President Franklin Delano Roosevelt, British Prime Minister Winston Churchill, and Free French commander Charles de Gaulle met for 4 years in the Casablanca neighborhood in an effort to discuss the strategy against the Axis powers. It was during the series of meetings that the Allies agreed to launch their continental counter-push against the Axis aggression uh, through a beach-heading landing on the French Atlantic coast. Following Morocco's independence, now this is what they call in Morocco. This particular Morocco that they're talking about was started in 1956. Before then, it was not a Morocco in North Africa. The Morocco is here. Now, the treaty over here, I'm back over here to the left, the treaty represented the second time that Morocco and the United States affirmed diplomatic relations between two countries. It is also worthy of mention that the Sultan Mohammed III was the first head of state in Morocco, the first country to recognize the new United States as an independent. In 1777. That's 10 square miles in Delaware Code in 1777 that the United States was granted as an independent country. 10 square miles, Delaware Code. The rest of this land in North America is called Morocco. This is in 1777. Now, this didn't have nothing to do with what was said over here about about the Axis powers that they were taking on charge against in World War II in 1917, 1918. You know what I'm saying? And by 1954, Moroccan got his independence. See, they playing games right here because they know better than that. You see what I'm saying? Following Moroccan independence in 1956. You see what I'm saying? So here is where the founding fathers, wrote to Sultan Muhammad III, to get permission from Morocco to settle and establish a place here on this North America continent, which is America, 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 Morocco, Morocco, our Morocco, man. But as for the protections of those particular Moroccan citizens still here and that have not defected into the corporate fiction that they've started to identify people here with under this pretense and licensing bonding system that they set up in order to pull the wool over people's eyes and create the caste system that they taught the children to speak in these commercial jargons in which I spoke of earlier. Licenses Now they trying to license your liberty. Now liberties are freedoms. Now how can they put licensing on your freedoms? And we just spoke about that in the previous paragraph in the case law stating that the sovereignty itself is of course not subject to law, for it is the author and source of law. And there's the case law for that. Yikwo versus Hopkins. To deprive the people of the sovereignty, it is first necessary to get the people to agree to submit to the authority of the entity that they have created. Now, what did I just show you? I just showed you that Morocco in 1777 bred life into the United States corporation. You see what I'm saying? They bred life into them and gave them the wherewithal and the 10 square miles of in Delaware Code to create and establish what is called a country, but later turned into a corporation because it went bankrupt and was overthrown by tyrants and became a state. So it's only a United States, actually, you know. Now, in this congressional record, they started the wordplay that led to the discovery of the foolishness that they tried to play because they know the independence wasn't won to 1956. For that particular country to be called itself Morocco, which was designed by the European powers, and they set up the regime of that particular so-called kingdom, which is actually a corporation called the kingdom, as they pretend to assert some form of authority over the people with their brainwashing and social engineering um, avenues and systems that they've placed in place with the licensings, bond creation of securities, through the securities. But here we go. Licensing and liberty. Now, no state shall convert a liberty into a license and charge a fee therefor. And that's Murdoch versus Pennsylvania. If the state converts a right, which is your liberty, your freedom, into a privilege, and then try to make a license out of it, they say the citizen can ignore the license and fee and engage in the right, which is your liberty, with impunity, without punishment. Shuttlesworth versus City of Birmingham, Alabama. Now, that's case law. Now, remedy for every injury. Every right, when withheld, must have a remedy, and every injury its proper redress. And that's William Blackstone. And in the third volume of his commentaries, page 23, Blackstone states 2 cases in which a remedy is afforded by a mere operation of law. In all other cases, he says, it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action in law whenever that right is invaded. Nunc pro tunc. Pay attention. Nunc pro tunc, now for then. And that's a writ that you can file. Because there's no statutes of limitation on fraud. And all suits filed in proper person, you are the injured party. Therefore, they must give remedy. And afterwards, on page 109 of the same volume, it says, I am next to consider such injuries as as are recognizable by the courts of common law, real law, and herein I shall for the present only remark that all possible injuries whatsoever did not fall within the exclusive cognizance of either the ecclesiastical, military, or maritime tribunals, or for that very reason within the reckonance of the common law courts and justice. For it is a settled, for it is a settled and invariable principle in the laws of England that every right, when withheld, must have remedy, and every injury its proper redress. And that's Marbury versus Mason again. Whew, that's a bad joke. So they must give remedy, especially when law is applied the proper way, when you're in your proper person, in your correct status, not an artificial person or a KKK census classification, with those Magna Carta classifications that they use for corporate um, organizations that they subverted to human trafficking venues. So sad. Now, the government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. And that's Marbury versus Mason again. Madison. Marbury versus Madison. I keep on saying Mason. I don't know. My partner will be talking about me or something. But anyway, that statute, which would deprive a citizen of the rights of person or property without a regular trial according to the course and uses of common law, would not be the law of the land. Yeah, that would not be the law of the land. And that's Hope versus Henderson. 15 NC, 1525 AM, DC 677. Now that's a smoker. Watch that. The right to be let alone. The right to be let alone, man. The most comprehensive of rights and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Olmstead versus U.S. 277 U.S. 438, 478, 1928. But look what this said, man. The right to be let alone. Come on, man. That's invaluable. If you can't exercise that right there, man, what we doing? The right to be let alone. Man, leave me alone. Oh, okay. And go on about your business, man. Why you can't exercise that right? Now, I already said you can carry whatever you want on your person. Now, on your peoples, I ain't gonna say your person because that might apply to a foreign jurisdiction. See what I'm saying? And that's what I meant to say about this word down here. Let me go way down here right quick. Did I pass it up again? Homestead versus U.S. 27. Okay. Now, the most valued right amongst men was the right to be left alone. And he said, upon the privacy of the individual. Every unjustifiable intrusion by the government upon the privacy of the individual. Now, the individual, now, that's a tricky word, too, now. That's one of them jurisdictional words they use to describe a corporate fiction, too, which is an individual. So I wouldn't classify myself as an individual, and I wouldn't use that in my writs either. Because it might be something that could be used to acquiesce you into their jurisdiction. So be careful about that, too, when you're writing your writs, man. And we're going to get into the writs, and I'm going to give you an example of some structures of writs. I think I'm going to do a special broadcast on that, too, to show you guys how to structure your writs to make sure that you're doing it right if you're coming into this for the first time and learning how to litigate on the international level. You understand? So we're going to go into all of that. The court belongs to the sovereign. Plaintiff, the people. You heard me? Now that's Black's Law Dictionary 5th edition, page 318. It defines the courts as the person in suit of the sovereign. The place where the sovereign sojourns with his regal regime, a retinue. However that may be, in the U.S. Supreme Court case, Isabel versus Stovall, the court was defined as an agency of the sovereign, created by it, directly or indirectly, under its authority, consisting of one or more officers established and maintained for the purpose of hearing and determining issues of law. In fact, regarding legal rights and alleged violations thereof, and of applying the sanctions of the law authorized to exercise its powers in the courts of law at times and places previously determined by lawful authority. So that's what a court is. Now we're going to get into this court on my next video. Like, share, and subscribe, man. I told you we're going to get in the meat, man, to sink our teeth. You hear me? That's what we got to get, man. It's time out for the milk, baby. We got to get to this table food. And it's the table food right here. Now we finna go into this court situation. And I'm going to have some more stuff ready, man, that's going to collab with this court video. And I'm going to drop for y'all. So y'all stay tuned, man. Like, share, and subscribe. We'll be right back with another video. So like, share, and subscribe. I'm a Rukans. Wake up. Slice of beer in the building, baby.